my name is Joe Bartolomeo. I am an Oregon Social Security disability lawyer with offices in Astoria, Oregon and Hillsboro, Oregon. And in today's video, I'm going to walk you through the elements of a Social Security disability claim. Basically what that means is I'm going to show you what questions Social Security asks when it's evaluating a claim and how you can prove your Social Security disability claim. Now, before I get into the elements of the claim, I want to make a few introductory remarks or a couple of heads up remarks. So first of all, if you're looking at a denial, you should appeal your claim within 60 days of the date on the denial letter. Social Security will say that it'll give a 5-day grace period or an additional 5 days to account for mailing of the notice, but I think it's better to go with the date on the letter and get your appeal filed. And if you're not sure whether it makes sense to appeal the case, you should just go ahead and appeal it, because if you don't and later, a year, 2, 3 down the road, you apply again, you may have given up several months, if not years, of benefits that are available to you. So when in doubt, appeal the claim denial. We help people with reconsideration denials. We help people with the initial denial. We do that without charge. And then if you want us to get involved, we can talk about that. But get that claim denial appealed if that's why you're here watching this video. The reason I'm making this video, though, is because over the years I've had people come in and talk to me. They ask whether it even makes sense to apply or if they're actually disabled. And those are all good questions. And there is quite a bit to establishing disability. Disability is a legal term in the statute. And if a doctor writes a letter and says, my patient Joe Bartolomeo is disabled, Social Security will not consider that at all. They have a pretty elaborate process that they go through to evaluate these claims. It's called the sequential evaluation process, or the 5-step sequential evaluation process. It's a series of 5 questions. Some of them you have to get the right answer on before you can go to the next step. Others, you get a second chance, or there's another way possibly of qualifying for benefits. So what I'm going to do in this video is walk you through each of the sequential evaluation steps, or the questions that Social Security asks when it's evaluating a disability claim. So let's get started. So the first question that Social Security will look at is whether you're involved or engaged in what it calls significant gainful activity. That is a legal term, and basically what it means is, are you working and are you earning money? That's really what it means. And it has to be over the long haul or over on a sustained basis. It can't be just a little bit here and a little bit there. So if you're working and earning over the monthly limit, Social Security will deny your application and not go any further. The amount of money that Social Security considers to reflect significant and gainful activity depends on the year that you're claiming your disability began. Now, before I went on to this video, I didn't look it up, but I believe for 2020, the amount of money Social Security will consider, or the amount of earnings Social Security will consider to be significant gainful activity or reflect that you're actually doing that, is between $1,200 and $1,300 a month. Stated another way, if you're working a job and you're making $1,270 a month, if that's the limit, then Social Security will assume that you're engaged in significant and gainful activity. Now, like any rule, there are many, many exceptions, and I'll give you a couple that come to mind. I have a case involving a client who has a significant health issue, and she is not able to work on a regular basis at all. She can work maybe an hour here, an hour there, but her boss, the owner of the company that she works for, has decided that he's going to keep her on the payroll until her benefits are granted. The issue there is whether that income is actually earned or if it's subsidized. Another example, long ago I had a client who was on the books working for his brother-in-law as a carpenter, but in reality, his brother-in-law was being a good brother-in-law and keeping him on the payroll even though he could maybe work an hour or two a day, maybe 2 or 3 days a week, because he had a really, really bad orthopedic issue. Those are subsidized work or accommodated work environments, and what Social Security will do is look at what you're getting paid and compare that to what you're actually doing and what part of that income is actually earned income. And then it'll consider the unearned income to be a subsidized work accommodation or a work subsidy. So if you're making $1,000 a month and 90% of that is subsidized, then $100 is really what the earnings are. Now, you can get into some pretty significant arguments with Social Security about this, but that's one example. Also, keep in mind that we're talking about earned income. You know, if somebody's collecting rents, or if they have a trust fund payment or something like that, that's not earned income, that's not significant and gainful activity. Significant talks about the work that you're doing to earn the money. Gainful refers to the money itself. So you have to be below the significant gainful activity level for the year that you are claiming your disability began. And if you want to look that up, you type into your Google search field SGA and whatever year you want to know what the limits are. SGA is short for significant gainful activity. Now, one more point before I move on. There is a whole different set of rules where the claimant, that's the person applying for benefits, was self-employed. And the reason for that is if you are self-employed, you are keeping your own books or somebody is doing it for you, and a lot of the income that you earn may not be reflected on your tax returns for whatever reason. You may take expenses, even though they could be totally legitimate, but the net income to the business, however you earn that income, whatever form your business is in, may not actually reflect your significant and gainful activity. So there's a whole separate set of rules that deal with folks looking to apply for disability who have a history of self-employment income. So that's significant gainful activity. Honestly, there's not a lot to it in most of the cases I handle. But before I leave, another thought, there is a concept called failed attempt at return to work or a failed work attempt. If you work and make above whatever the limit is, let's say you're making $2,500 a month, which would be well above significant gainful activity thresholds, but you only do it for 3 months, and the reason you leave is because of your disability, Social Security will consider that a failed attempt at a return to work or a failed work attempt, however you want to say it, and it will not count against you. But if you work at a sustained level of SGA or significant gainful activity for 6 months or more, you're out of luck. That is, even if you leave your employment because of your disability, that's going to be considered significant gainful activity. It will not be a failed attempt at a return to work or a failed work attempt. And you will have to start over with the date you left work as the date when your disability began. So that's the basics on significant gainful activity. So let's move to the next question or step in the evaluation process. All right, so now what we're doing is we're on the second question or step on the evaluation process that Social Security performs to evaluate your claim for disability. And if you have established to Social Security that you're not engaged in any significant gainful activity, which is basically working and earning money. Now the question is, do you have a severe impairment? And Social Security likes to use the term medically determinable impairment. And what that means is that you have some kind of limitation, and we can look at the medical records, and that verifies or validates the limitations that you're claiming. You can't just walk into the Social Security office and say, I have a really painful lower back problem with pain shooting down my legs. I have to lay on my back or in a recliner 2-3 hours a day. I don't get a good night's sleep. Some days I can't get out of bed at all. And that may all be true. But unless there's some medical evidence like an MRI or an X-ray or a doctor's clinical findings that verifies or backs up what you're saying about how bad things are, then you will not continue on with the claim. The Social Security Administration will deny the claim. They will not go any further. Now, that being said, this is, in my opinion, for whatever that's worth, this is the easiest element or question or proof that I think you can make on your claim. And the reason is you only have to show that your medical problem is causing more than a minimal interference with your ability to do work activity. So, and that's not just any work that you've done in the past, it's work activity in general. So if you have a medical problem that's limiting you pretty much in any way, you're going to get over this threshold of whether you have a severe impairment. And I can only remember, and I've been doing this, it'll be 30 years, actually it has been 30 years that I've been doing this. There was one judge who is now retired who would find that my client was not engaged in, was not, or didn't have, excuse me, they didn't have a severe impairment. And I believe one or both times that decision was reversed and it was sent back for another hearing. So you just don't see that happen very often. So that's step number 2. Now we're going to go to the third step, and we'll talk a lot about that one. So now we're on step number 3, and the question that Social Security will ask is whether you meet an impairment listing. So before we explain whether you would or would not meet an impairment listing, we need to explain what impairment listings are. There is, in the rules, there is an appendix to the rules, kind of like an attachment. And what it is, it's a book of impairments. That's the way I describe it. Actually, before we all went online with reading the law and rules and regulations, there was an actual book, and it was called the Blue Book. And the Blue Book contained all the impairment listings. So it's like a catalog. It has 12 chapters. Each chapter is dedicated to a different type of medical problem. They group them together. So for example, if you have an orthopedic issue like a lower back problem, arthritis in your hips, your knees, something like that, that's in the orthopedic chapter, chapter 1. If you are suffering a mental impairment and it disables you from work, and those are real things, by the way, if you have a mental impairment that keeps you from being able to work on a regular basis, then the Social Security Administration will go to chapter 12, and in that chapter there are listings of different mental impairments, and each of those is like a checklist. So what Social Security does is when they ask whether you meet an impairment listing, they figure out which one they should apply, and then they go through the checklist and they check off each box to figure out whether you meet an impairment listing. Now they're kind of like checklists, but sometimes they're a lot more involved than just a 1, 2, 3, 4, 5 checklist. But what they're doing, if you meet an impairment listing, what Social Security is looking at is this an obvious case? Because really what they're doing is looking at the medical records, and if you meet an impairment listing, Social Security is pretty much saying, look, this is so obvious to us that you cannot work. I mean, if your medical records include all of these things, there's no way you can work we're going to stop right now. We're going to approve your claim. You're on disability. Everything's great. And those do happen. Those people are found to meet impairment listings a lot. I don't see those cases because they've been approved. They don't need a lawyer to help them on the case. I believe, and it's pretty much true, that Social Security uses the impairment listing to screen out the obvious cases. And so if you meet an impairment listing, you're found disabled, that's the end of the road. No more questions need to be asked. You will be approved. Most, if not all, of my clients do not meet an impairment listing, or it's been decided that they do not, and either they do and it was incorrectly decided, or by the time we end up at hearing, their condition, unfortunately, has gotten worse and now they meet an impairment listing, or there's medical evidence that the prior decision makers didn't have and were able to find it, and then a judge looks at it and figures out that in fact my client does meet an impairment listing. So the impairment listing, if you meet it, that's great. If you don't, the good news is you're not out of luck. This is not one of those elements where if you don't get the right answer, they shut you down and that's the end of the game. You can still go on and you can still prove your disability claim. So let's talk about that next step in the evaluation process to see whether you are disabled according to Social Security. Okay, so we're now at step 3. So just a quick review. Question 1 is, are you engaged in substantial gainful activity, which basically means are you working and earning money? Step 2 is, do you have a medically determinable impairment, which means do you have a medical problem that causes you at least some limitation in your ability to work, and is there a medical record out there that points to that? Step number 3, are you one of those no-brainer situations where you meet an impairment listing? If you don't meet an impairment listing, now we're on step 4, which is called residual functional capacity. And so the question is, what is your residual functional capacity? And all that means is, what can you still do on a sustained basis, day in and day out, in a work setting? Social Security has already figured that you haven't worked. They already have determined that you have some kind of limitation in your ability to work. Now the question is, what are the specific limitations on your ability to do work activity? And what Social Security will do is see whether you can do light work, sedentary work, heavy work, medium work, and all of those descriptions of work activity have definitions attached to them. Usually a lot of it has to do with what you can lift. A lot of it has to do with how long you can sit, how long you can stand. There are other limitations that don't fit within those definitions, like postural limitations. That deals with actually squatting, bending, stooping, kneeling, crouching, crawling, climbing, things like that. And if you're making a claim for a mental impairment, the kind of things Social Security will look at is your ability to concentrate, your ability to focus, your ability to understand and follow directions, your ability to work without interruptions from psychologically based symptoms, your ability to show up on a regular basis or get along with other people or work with customers or supervisors or adapt to changes in the work environment. So there are a lot of aspects to the mental side of doing work, just like they are on the physical side. Social Security primarily relies upon the opinion of doctors that are hired as independent contractors to review your file. It's just their opinion, and often they're wrong. And they'll come up with a description on what they think you can and cannot do. And if they think that even with those limits, you can go back to the work that you've done before, or there's other work that you can do, they will not find you disabled. So this is probably the most important question that Social Security will ask. They will determine what you can and cannot do, because from there, everything else follows. And this is where the battles are won and lost. And Social Security won't just consider medical opinions. They will look at your records. They'll look at what your daily habits are, what your daily activities are. They'll consider your testimony if you go to hearing, or what you filled out in a form if you haven't yet gone to hearing. So residual functional capacity is really an important aspect of the claim. We often seek that opinion on what you can and cannot do from your medical providers because they're in a really good position to give an opinion on that kind of an issue. So that's residual functional capacity. Now, I kind of alluded to the last couple of steps, the last step, and we'll talk about that next because that's where the decision really is made. So the title to this part of the talk is Other Work, but really it's a two-part question. It's now that we know what we think you can and cannot do, we're going to go back and look at all the jobs that you had in the 15 years before your disability, before you claim it began, your alleged onset date. That's the date that you're saying you became disabled. We'll go back 15 years. We're going to look at the physical requirements, the mental requirements of your job, the skill level, and we're going to look at what we think you can still do and decide whether you can go back to any of your past relevant work. The past relevant work is the work that you've done in the 15 years before your alleged onset date, which is the date that you're claiming your disability began. If Social Security thinks that you can do that, your claim is denied, everything stops. But if they don't think, if they agree with you basically, and they decide that you are not going back to any of your old jobs, now what they're going to do, if you're under 50 years of age, is they're going to see if there is any other kind of work that exists in the national economy that you can still do. So the example that I use is, let's say my client is a 40-year-old logger, and that's all they've ever done. Running up and down hills, carrying cables or a chainsaw, whatever, but very, very strenuous work, very dangerous work. And they blow their knee out and they have major surgery on their knee. And the doctor says, sorry, no more uneven ground. No more lifting more than 50 pounds. You cannot go back out into the woods again. But that injured worker or that injured logger could still be a cashier. They could still work at an auto parts store. They could take tickets at a movie theater, something like that. Even though the pay scale will be much lower than what they were earning, if that worker is under 50 years old and the Social Security Administration thinks they could shift into lighter work, they are not disabled. And that available or that existing work it's not limited to where you live. If there is a job that they think you can physically and mentally do that exists in the United States of America, you are not disabled according to Social Security. And the reason they look at it nationwide, in my view, is they don't want one standard for a logger in Clatsop County and another standard for, say, a construction worker in Washington County or Multnomah County or Memphis, Tennessee, for that matter. They want a uniform standard that they apply to everybody in the whole United States. So if there's a job or if there are jobs in significant numbers, and they don't need to be available, they only need to exist, that you can do, then you're not disabled. Now the burden is on Social Security to find those jobs, but it's really not that difficult for them to do. So really, you have to prove, if you're under 50 years old, you have to show that you cannot do any kind of competitive work at all that exists in a national economy. And many times it comes down to really being able to show up on a regular basis at the job site, or when you're there, not leaving early or not having to take excessive breaks. That's really what it boils down to, because we're not just talking about when you're having a good day or not a good day. We're talking about the whole long term or working on a sustained basis. So I want to cover that's the claim. That's it. Those are the 5 things. But I want to talk a little bit about how age can affect your application and your evaluation. So let's talk about that. So I have a tendency to repeat myself, especially when I tell jokes. And the joke that I tell my clients who are over 50 is, this is the one good time, maybe the only time, that it is to be older. This is the one good time, or the one time that being older is an advantage. And the reason is, if you're over 50, Social Security, and it depends on your past work, they will not, in many cases, expect you to be able to do any other kind of work, or stated better than that, if they find other work that you can do, you may still be disabled. Again, it depends on the past work that you've done in terms of your skill and the physical requirements of the job. And then when you hit age 55, there's another set of rules that relaxes that standard a little bit more, so that you may technically be able to do certain kinds of work, but because of your age, Social Security assumes that you're not as able to adapt to change as you were when you were younger, and they will find you disabled. And then at age 60, it's even better, because they really narrow what kind of work they expect you to be able to adapt to. It has to be very closely related to the work that you've already done. So that's how age affects your Social Security disability claim. And I think I've pretty much covered it. If you had to boil it down, though, all those 5 questions that we went through, basically what you're having to show is that your medical condition limits you to the point that you're not able to hold any kind of work on a regular and sustained basis. That's what you have to prove. And Social Security will look at your medical records, medical opinions, statements that you make. If you go to a hearing, they're going to consider your testimony. They'll even consider testimony or statements from people who know you, like family members or friends. So, I hope this was helpful. If you have more questions, you can go to the website. I have a Social Security Disability Guide. It's a free consumer guide that you can download. There's no obligation. We will not give out your name. It's just, you can take a look at that. It's a good reference. You can also check out the website. There are a lot of articles on these topics on the website. If you need to contact us, you can do that. There's a contact button. If we're not able to help you, we can at least point you in the right direction. If you have a denial, we will help you appeal that denial. And then after reviewing the claims file, we decide whether there's enough for us to work with. And if you have questions about how our fee agreement works, there is information on the website as well. Thank you so much for watching. I hope this video was helpful. Take care.